Imagine walking into a supermarket, picking medicine off the shelf, and heading to the cashier. At what point do you actually form a contract of sale? Is it when you take the medicine from the shelf, or when the cashier accepts your payment? This simple act of shopping sparked one of the most famous English contract law cases. Pharmaceutical Society of Great Britain versus Boots Chemists in 1953. Background story. In the 1950s, self-service shops were a new idea in England. Traditionally, customers would ask a shopkeeper for goods. The shopkeeper would make an offer, and the customer could accept or reject it. Boots introduced a self-service system. Customers picked items from shelves and brought them to a cashier for payment. Among the items were pharmaceutical drugs, which by law had to be sold under the supervision of a pharmacist. The Pharmaceutical Society argued that this self-service method broke the law because the sale was made when customers picked up the drugs from the shelves without pharmacist supervision. Boots argued otherwise. The real offer happened only when the customer presented the goods at the cashier's desk, where a pharmacist was present to supervise. The question reached the Court of Appeal, and the outcome became a cornerstone of contract law. IRAC method breakdown issue. Was the display of goods on shelves in a self-service shop an offer to sell, or was it merely an invitation to treat? In other words, did the contract form when customers picked up items, or only when they paid at the cashier? Rule. The general principle of contract law. Offer. A definite promise to be bound once accepted. Invitation to treat. An invitation for customers to make an offer, not binding until the shop accepts. Common law had already established in earlier cases that advertisements, price tags, and shop displays are usually invitations to treat, not offers. Application. The court analyzed Boots' self-service system. The goods on shelves, even with price tags, were not offers. They were invitations for customers to pick up items and bring them forward. When a customer placed items at the cashier's desk, that was the offer. The cashier, with a supervising pharmacist present, had the choice to accept or reject the offer. Therefore, the law requiring pharmacist supervision was respected. Since the final contract was only made at the counter, the court rejected the Pharmaceutical Society's argument that the sale occurred at the shelves. Conclusion. The Court of Appeal ruled in favor of Boots Chemists. The display of goods on a shelf is an invitation to treat, not an offer. The contract is completed at the cashier's desk when payment is accepted. This case confirmed that shops are not legally bound to sell an item simply because it is displayed. They may refuse to sell at the counter. From this case, every trip to the supermarket became clear. In the eyes of the law, picking an item from the shelf does not mean you have a contract, yet it is only when the cashier accepts your payment that the deal is sealed. This principle continues to shape consumer law, e-commerce, and retail practices worldwide. If you found this case breakdown helpful, make sure to like this video, subscribe to the channel, and hit the notification bell so you never miss more case law explained in simple terms. Share this with your classmates and keep building your legal knowledge step by step.